Welcome today to a lecture that we're having with Rosemary Dupont. She's kindly offered to talk to you today about mediation. And as you know, as I've said to you before, she's extremely experienced in the area. She's a qualified and experienced mediator and arbitrator. She's done hundreds, I think maybe even thousands of conciliations, arbitrations and mediations, and she's actually even worked overseas at the request of the Australian government. She's on also a number of panels, both government and court panels. She runs her own successful company in dispute resolution services, and she's also the chair of the ACT chapter of the Institute of Arbitrators and Mediators. Now, I just wanted to say a few other things, and that is that, look, I think in the first lecture somebody actually asked me, well, what kind of traits would you need to be a mediator? And I think what I said to that person was, well, traits like Rosemary Dupont, and that is someone that's really positive, that's optimistic, that's empathetic, and that's generous. And I think that Rosemary exhibits all those things, and I think that makes for certainly an extremely good mediator. So today we have the privilege of Rosemary giving you a lecture on mediation and that mediation process, and afterwards we'll also do a role play simulation, and that will be now, I think it'll be with Athol and myself as the parties, and possibly Rosemary, but that will be up to her. All right, well, thank you, and let's welcome Rosemary.
Thank you, everyone, and thank you, Doris, for inviting me today. I really enjoy sharing my knowledge. So what we're going to do today, briefly, is I just want to tell you a little bit about the Institute of Arbitrators and Mediators Australia, because I am actually representing that organisation today. I'm going to just give some very basic principles about mediation. I'm going to go over the 10 steps that IAMA teaches in its mediation training for mediation, and I believe that they provide a very good framework that is a very reliable framework for mediation. At the end, I'm going to just talk a little bit about power influence in mediation. I've got 50 minutes, and at the end of that time there'll be 10 minutes for questions and answers, and then there'll be a role play as Doris mentioned. So just talking about IAMA, the Institute of Arbitrators and Mediators Australia was established in the ACT in 1975. It was originally the Institute of Arbitrators Australia, and it was created because in the courts a lot of the judiciary found it quite difficult to deal with very complex construction disputes, and so early on in the piece, and still today, a lot of the arbitrators, because most arbitrations are in the building industry, were builders, architects and engineers and so on. But as ADR became more prominent over a wide cross-section, the Institute was rebranded and became the Institute of Arbitrators and Mediators Australia. It is a national organisation. There are only a couple of organisations, ADR, that are national. The difference for our organisation is that we support a range of ADR processes which the others don't do quite as widely. The Institute is an educational and professional body. It's not an employment agency, although we do accept referrals for arbitrators, mediators and so on. So the range of ADR processes that the Institute trains and does take nominations in is arbitration, mediation, adjudication, expert determination, and just recently probity was introduced. There is another one that's up there, and that's a dispute resolution panel, And one of my colleagues, Tim Sullivan, will be here next week to give a lecture on arbitration, and he's an expert in dispute resolution panels. In fact, was telling me he is on the, he's just been asked to do one in Indonesia. It's a very interesting concept, so do question him on that. I know that on your reading was literature from NADRAC, and I'm sure you would have read their definition of mediation. But just to go over some of the important parts of it is that the mediator assists, they are a neutral third party, they identify the issues, develop options. The process generally talks about not have an advisory function, and the process that we encourage within the Institute is a facilitative one, and I'll come back to that. But certainly that's supported by NADRAC, so it's not advisory or determinative. And the mediator certainly has a role in determining how the process is run, but not the content and the outcome. So I put that cartoon in. I had a little bit of a period in my life where I had migraines, and when I saw that, I thought that was very appropriate. I related to that very, very well. Okay, so some of the basic principles of mediation, the model that we teach at the Institute is that it's consistent with the National Mediator Accreditation Scheme. And if you're interested in mediation, you'll hear a lot more about that. It's called NAMAS accreditation, and NAMAS accreditation comes from a board called the National Mediator Standards Board. So as I mentioned, we use a facilitative model. The NAMAS model and the IAMA very much focuses on self-determination and the right to self-determination, and encourages the parties to participate. It's interest-based as opposed to being rights-based. Now, some examples of that would be you might have a building contract, and it's evident that that building contract has been breached in some way, but it may not be in the interests of the principal builder to take the matter to court. And the reasons for that could include things like the court process will take a very long time to get finalised. Likely to cost a lot of money. You may not get the outcome that you're seeking, but you also may have had a subcontractor that you're having a dispute with that is actually a very good subcontractor, and you just have a dispute at that time. And it may be your interest that you maintain a relationship with that person, and certainly interest-based processes like mediation allow for that. So that comes on to that it has the capacity to repair and build relationships. The process is confidential, and that's something that attracts a lot of people to it, and it encourages resilience through the fact that it's self-determinative. You know, when people have input into deciding the outcome, they're much more likely to adhere to that and accept it. Mediation is based on procedural fairness, and finally, the role of the mediator, it's very important that they're impartial and neutral. Now, they're just a few of the sort of principles. There are others, but that's the most important ones. So we teach 10 steps, and I think the training that we provide in IAMA is very similar to that provided by other organisations. And what I'm going to cover in the next 45 minutes or so is just a very brief outline of each of the steps. Now the slides have got a lot of detail on them, and Doris is going to ensure they go up on the Noodle, so that those people who are interested in studying it further can do that. But the 10 steps, and I think any training in mediation will have very similar steps. They might have a different name, they might have a different combination, but they will all cover the same things. And this is what we call ours. So diagrammatically, what you have here is step 1, which is the preparation that you do before you actually have the parties together. And that's called the preliminary or the preparation stage. Then once, if you proceed with mediation, then the next stages 2 to 9 actually occur with the parties, with the mediator and the parties together. And finally, step 10 is a debriefing and professional development type of step. You'll notice there that the arrow goes from the past to the future, and in mediation, that's what you are trying to do. And sometimes in the process, you have to step back a bit before you can move forward. But the process is very flexible and allows you to do that. All right, so the first part is that preparation, assessment and intake. I always strongly believe the time put into this step is very worthwhile. In some organisations it's called intake. With Relationships Australia or here in Canberra, the Conflict Resolution Service, you have an intake officer that deals with the intake. I think that the main reason that occurs is because a lot of these organisations, these community organisations, have limitations on expenses. But in the commercial world, this preliminary part is really worth taking your time to work through. So you meet with each of the parties, and it's a time to introduce yourself. Of course, at that time, you're making sure there is no conflict of interest. You're making sure that you've got the right qualifications and skills to mediate that dispute. You're also looking at, is this dispute right for mediation? And it might be that, in fact, it might be more suitable for something else. And you'll get a little bit more sense about that as you go along in regards to the parties' perhaps attitude to the process. So it's a time where you talk about things like agreements to mediate and confidentiality. Mediation is a voluntary process, so accepting when it's of course referred from the courts, and to a degree it is still very much voluntary. I mean, people can opt out, it's just that they'll opt into court. So you're wanting to check with the parties that they are coming voluntarily. One of the very important things, particularly in commercial disputes, is you want to make sure the parties that there have the authority to settle. And I have heard of such situations where very long and complex disputes have run their course and sort of almost got to the other end, and lo and behold, the party will say, oh, well, by the way, I need to go back to the company secretary or the president or whatever to get a sign off on this, and it can turn everything upside down. So you're wanting to make sure that applies. The other thing is that you want to make sure your parties are there in good faith, and that they're not just there to participate in a fishing spree, that they are very genuine. And that good faith might determine or might assist you to decide whether mediation is an appropriate process. Because if your parties are coming not to negotiate in good faith, but to perhaps get back at the other party, or they're very positional, then mediation is probably not going to be the right place. But it's also this step where you can persuade them perhaps that mediation would be a good way, and that's because it's interest-based, and you can start to focus on what their interests are. What do they really want to get out of this process? And there's lots of different skills you can use to clarify that and to help them along. It's a bit like a sort of coaching, mentoring sort of phase. So you might be using things like role reversals. You know, what if the other party was here, or the other parties, what do you think they'd be thinking about or saying? What do you think they'd be wanting to get out of this? You can also talk to them at this stage about things like, you know, what are the alternatives if you don't settle this dispute through mediation? You know, what could be the worst thing that might happen? And on the other hand, you know, if you work on it and participate in it, what might be the best thing that you can get out of it? So if you feel that the matter is suitable for mediation and the parties are coming in good faith, then the next part you do in this is do the practical stuff around about organising mediation. And that might be organising a venue, resources, and so on. So step 2, you know, the parties seem to be, you know, really prepared to participate and work this out, probably think it's worth building a relationship or trying to. You've come to the mediation and the parties have arrived. So the first part of that is obviously to settle people. My experience is that often people are quite anxious when they come to mediation. Despite the fact that the word mediation is used all the time, a lot of people haven't participated in mediation, so there's a degree of uncertainty and anxiety. If you've done a good job at the first step, then you would have reduced that quite a lot. There's just a few things that you do as a sort of opening way for the mediation. And I always find that it's good to reiterate the things that you might have said in the preliminary meeting. So it's good to confirm that the process is confidential as far as the law allows. That's the term we use. That they are there in good faith and that they can leave at any time. That the process is without prejudice. And it's also important to reconfirm your role in the mediation process, which is as a neutral and impartial person who's not going to make decisions. Now, in some mediations still, the mediator will have an advisory role, and particularly where the mediator might actually be called a conciliator, then the conciliator will be acting on behalf of a piece of legislation or an act, and their role will be to give advice on you know, what might happen if the matter goes to court. But still, there are mediators who are experts, and sometimes parties choose to have an advisory mediator. I'm talking here mainly about a process where it is facilitative and you're not giving advice. Right. You've got to check that there is an agreement to mediate and a confidentiality agreement. And if the parties are represented or have support people with them, they will have to sign a confidentiality agreement. There is a lot of sort of conversation around these days, the extent of confidentiality. Some people say that, you know, confidentiality doesn't really exist in mediation. I think confidentiality, to the extent the law allows, is in fact a a reason that encourages people to come to mediation, particularly in commercial disputes or even interpersonal disputes. Being able to have a conversation that remains in the room obviously can be very, very important. And you'll often hear that part of the agreement from a mediation was that the agreement will be confidential. So I think that I've covered as much there as is important. You know, you just check off with the parties that they have any questions. Obviously, if there's documents to be exchanged, that would have been done in the early part, so there's no surprises. You know, mediation, we say mediation is not about facts, because if it's about facts, maybe there's some other processes that might be better, but in particularly commercial mediations, it is still and is likely that there will be documents of some sort. So that's over. By that time, you feel that your parties are feeling a bit more confident and calmer, and you get started with the mediation, the next step. So the next step is what's called statement taking and summarising. When you meet them in the beginning, you instruct them that you're going to do this, and I always say to people, come prepared to just give a brief statement about why you've decided to come to mediation. And that opening statement is just brief, outlines the main issues, and it sets the scene. The mediator, after all the parties have done their opening statements, will give a summary of that. And I've put up there that it's important to use reported speech, because you're not interpreting as a mediator what they're saying. You are actually facilitating and summarising. So, interruptions in mediation, unlike court processes where people know what the rules are and have to stick to it pretty much, mediation is a much more informal process, and you certainly are likely to have your parties interjecting. And if that occurs, it's very important for the mediator to be impartial and fair, remembering that it's a process that's based on procedural fairness, and that you maintain the environment so that people feel they're being heard. So there is, for the mediator, a role to manage the process. So just looking at number 10 there, which I think is very important, the mediator will certainly be checking in that the statement or the summary is accurate, and that allows the parties to correct anything that they've said or that might have been misunderstood. It's really important in mediation to note areas of agreement, because when people are in dispute, it always seems like everything is different. They don't agree, there's no agreement, but in fact there often can be a lot of agreement, and I think to point that out sort of sets the scene for the parties that they've got perhaps more similarities than they've got more differences. And it says there about expressing strong feelings. That's important to do. Again, you've got to be careful that you're not seeming to be impartial, but to clearly indicate that you understand how important this matter is, can help the process along. So moving along, the next step is listing an agenda. And when I do mediations, I always say to people, there's two reasons for doing this. The first one is to manage time. Right? Where you're doing mediations in a community environment where funds are limited, often there is only a very specific amount of time allocated. It might be 2 or 4 hours, not a lot of time. You therefore have to manage that time very carefully. The other thing is you want to make sure that as the mediator, the parties leave the room having discussed absolutely everything that's important for them to discuss. You can imagine what it'd be like if, you know, in a, say, a family relationship dispute, and you walk out and said, I didn't talk about, you know, the sharing of custody or time for the children, or what's going to happen to the dog, or something like that. So they're the two reasons for setting an agenda. It's a part of the process that's very important, but it's not a part of the process that one wants to spend a lot of time on. So therefore, the guide for this is that you use neutral language, right? So nothing that's going to flare up. I'll give you an example of that. In workplace disputes, people will often say, I want to talk about bullying and harassment. Right? Now, already in your preliminary meeting, if they've said that, you might say something like, was there an investigation? You know, is this fact? And remind them that making statements that are inflammatory won't help the process. So something like bullying and harassment might be reframed to a more neutral language, which might be, for instance, behaviour or communication. And the reason for that is you do not want to spend an hour arguing over a word at this part in the mediation. So neutral language, the list is a mutual list, so all the parties contribute to it, and it's all of the parties' concerns. It's not up for one party or another to say, oh no, I don't want to discuss that today. And I've just put there as a guide, obviously you've got to have enough to talk about, so maybe between 2 and 9 topics, but it depends on how much time is allocated for your mediation. Certainly I have done mediations where there is only one issue and that's it, and you can't, you know, make more out of it than that. And remembering that it is their process. Right? You're directing, you're facilitating it, but you're not dealing with the content. Now, we come to the exploration stage of a mediation, and that's the engine room. Because you wanting to be seen and to be impartial, it's a good idea to not set any priority to the topics, and to allow the parties to take turns in choosing what they talk about. Just going back to, I've just remembered something in terms of the agenda setting, and that is you as a mediator are quite an influential person. So as soon as you start making suggestions about something, parties are likely to think that those are the important things, right? And that can lead to a perception that you're not being impartial. But I think if your parties get to the end of their list and there's something, you know, very clearly missing off the list, then, you know, you wouldn't be doing your job properly without sort of reminding them. So, for instance, if you were dealing with a court referral, say for an assault, and there wasn't on their list about going back to court, you'd certainly be wanting to check in with the parties that whether that should be up or not. Okay, so in the previous part of mediation, the parties are encouraged to start off talking to the mediator when they're doing opening statements. But at this part of the mediation, you certainly want to be having your parties communicate with each other as much as possible. I mean, after all, one of the biggest reasons why there's disputes is because communication is poor. I haven't addressed the issue of support people here, really, very much. In some jurisdictions, legal advisors are not allowed to attend mediations. In others, they're discouraged. And certainly there's a trend towards people being self-represented. So you need to set very, very clear ground rules, particularly during this part, about who's going to do the talking and what the roles of the various stakeholders are. In terms of lawyers, I do try to get the parties as much as possible to talk for themselves, and for the lawyers to, or the legal advisors to just sort of step up when some additional information is required. But these are the sorts of things that need to be established up front. So the parties start talking about their issues. What you don't want is them settling too early, because mediation is an opportunity to really explore all the issues and consider as wide as possible a range of options that might settle the dispute. And if I can give you an example of how that works very well, a family law matter comes to my mind. And that was a situation where a husband and wife had separated. They were making arrangements for the way they were going to manage their children. And, 99% of time, what happens is that the children will spend, a week with mum and then a week with dad or whatever. But this arrangement, through not deciding on options quickly, they came up with the option of having a house where the children stayed all the time, and the parents came into the house, and that that's quite out of the square. And if agreements had been made in a rush, then there was no way that sort of idea could have come to fruition. So usually if people start to settle too quickly or make offers, we encourage them to sort of write it down, just leave it there, continue the conversation, and come back to those later, so that there is a really good understanding of why people are there and what their issues are. And it's amazing how often there is a great deal of clarity that comes that wasn't there before, and it really changes people's minds on things, so that people who might come sort of being positional can go, oh, I didn't realise that, and I've certainly seen that a lot. What I find is that even though you've got an agenda, when the parties start talking, they will cross over their agenda items. But the mediator in this role, as the facilitator, is summarising all the time, is using very good communication skills to ensure that each party understands what the other is saying. We like to encourage mediators to use complex questions and open questions as opposed to closed questions where you only get a yes or no. So again, you're all the time bringing in information into this process. Now, during the exploration stage, but in fact it could be anywhere in the mediation, we have what's called separate meetings. It's sometimes called caucusing. This is an opportunity during the mediation where you can meet separately with the parties to check on how things are going. These are confidential sessions. The mediator does not bring anything back to the mediation, and certainly wouldn't want to be breaching confidentiality. The mediator, talks about that confidentiality, the reason for the meeting, which is just to check in, and we'll note that it's generally brief. Now, I've been in mediations where there's been lots of separate meetings, and I've been in some where there's been none, and I've been in some where they're very long meetings. So there's no rule, but it's a process it's a component of the process that is very important, and if used well, can assist to sort of get to that end stage of being able to settle the matter. So what happens there is you start off with one party and you sort of check in to see how it's going. You check in to see if you think there's going to be some possibility of settlement. If there's not, it's a time to sort of find out what the concerns are. And it's a time, again, to do a reality check, remembering you've only got one party and their support team in the room. So it's a time when you can be very open. You might say, well, you believed that the roof wasn't fitted correctly, and that as a result of that there was leakage. And during the mediation, you might have heard that there was interruptions from the rain, and there was a strike on, and so hearing more information might change the person's view of the situation. At this stage, we do a lot of reality checking, and that is, if what you want is A, do you think you're going to get A? What do you think the other party or parties are thinking at this stage? What do you think the other parties will be wanting to achieve? I think in this course you're doing something on negotiation, and you'll know that in negotiation one of the most important things is preparation and planning, and certainly the parties need to be thinking, what is the other side going to want? Because it is possible that what the other side want is something that you can easily give up, because you want something totally different. And you won't know that until you've had a very good conversation about what the issues are. So in negotiation, you use what's called a BATNA and a WATNA. So I referred to that earlier about what's the best alternative, what's the worst alternative. So if you say, well, if you don't settle this matter today, what do you think will happen? People might say, oh, we'll end up in court. Well, what will that mean? Oh, well, we'll be still waiting for 18 months to get this matter before, a judge. It's going to cost me, $40,000. I won't get my roof fixed. And it's a real reality check for people to sort of say, well, is there something that you can come up with that worst situation doesn't eventuate, right? And if it's the reverse, what would be the best thing you can get? If you want the roofer to mend the roof, then what perhaps can you offer him, all right? And if you want it done in a couple of weeks, maybe it is you've got to pay him a little bit more so he has people to do overtime to get the roof done. Would you be prepared to do that? All right? So that's what you're doing. So you can see it's a very powerful part of the process. Now, as I said before, the mediator is not going to be the person who brings any new stuff back to the mediation, but you're certainly encouraging the parties to do that. Would you be able to make that offer or provide that extra piece of information for the other parties? So you're encouraging them to do that. In mediation, we encourage the use of a lot of boards and butcher paper, and the reason for that is that most of us as adults are visual people, and so if we see things up, we take it in more clearly. And so the normal thing that I would do at this party is I'd have a big whiteboard and I would write all of the options up on the board. It's like brainstorming. I know you've all done brainstorming. The idea is to put up as many options as you can think of. Doesn't matter whether they're out of left field or not. You ask people not to assess those in any way. And you encourage them to be as creative as they like, because that's how you get change, basically. You write all of those up, and when that's completed, you go back and try to find, we try to use an objective criterion. So you don't want people having argy-bargy at this point on what they prefer over one option over another. So an objective criterion might be, well, what's the standard used in the building industry? Right? What's the standard used for deciding what sort of flashings are used on ceilings? I actually know a lot about flashings and leaking ceilings. There's lots of disputes about those things. Sometimes it's just, look, we can agree really quickly to a couple of these, and these other ones are going to lead a lot more negotiation. So, you're encouraging your parties, and if they see that there's something that they can agree on, it's very encouraging for them to keep the process moving along. At the end of this process, you should have a really good set of options that then become part of your agreement. And it's important at this stage or the next stage to really drill down to get the detail. Now, if you've got legal advisors in your mediation, that'll often be done by the legal advisors. But if you don't, and most often mediators will not have legal advisors, then it is responsibility of the mediator to make sure that it's very clear what's going to happen or what the agreement is. So we talk about, who's going to do something, when are they going to do it, where are they going to do it, and how much is it going to cost. And then finally, well, it's not actually finally, but it sort of feels finally, you get to write up the agreement. I think that most mediations are written, and the parties sign off on it. Sometimes there's an interim agreement, the parties just can't finalise it because they don't have enough information. For instance, the parties in the scenario that I've used about the roof might decide they'll have an expert determination done on the matter and then come back to mediation, because expert determinations are not binding. Okay? So if it's an interim agreement, then it's written up as an interim agreement. If there's no agreement, then the mediator terminates the mediation. We'll check in with the parties what they want to do from there. It might be that the mediator makes a suggestion about where the parties can go to next. Sometimes during the mediation process, the mediator has to terminate the process. This might occur, for instance, if you feel one party or another is not coming in good faith. It might be that a party doesn't appear able to represent themselves, to have, the power to settle. I do a lot of mediations involving people with psychiatric illness, and certainly in those disputes, that's a concern and an issue that you've got to have. finally, no, again, I can't say finally, but the final part of having the people together is the closure. Part of the closure might be a follow-up mediation to review how the mediation agreement's done. That's very, very commonly done in workplace disputes. But even in other disputes, particularly if it's complex, the parties might appreciate the opportunity to come back and review. But certainly the mediator will be confirming or reaffirming the confidentiality, confirming the outcome, and putting some closure around the mediation. One of the issues that may need to be addressed at this part is, announcements to the outside world. Is there anybody else that needs to know about this? So if it was the building dispute, the union might need to know that the matter's been settled, and the parties will agree to that. Or the parties might agree that their agreement will remain confidential for just the parties in the room. Right. And finally, the last step is the sort of debriefing and professional sort of side. So if you work in an agency, a community agency where there's an intake, you will have to keep records. And in keeping those records, you need to do all the follow-up. It's always good in our practice, it doesn't matter what profession we do, that we have some reflection about how we've gone. And sometimes there'll be a mediation that's pretty straightforward, but there'll be times when something comes out of left field, and it's really helpful to be able to improve your practice, to talk with another professional about that, or to get some hints about how other people might deal with it. Now, obviously, the confidentiality is maintained at this part, but it is an important part. And the other issue around professional development is actually participating in ongoing learning, and it's not any different for lawyers or accountants or engineers. It's a very important part of maintaining your information and networking. So when Doris and I were talking about today, she thought that it was very important to just raise the issue of influence and power. This is an ethical quandary for a lot of mediators. You're going to have in some mediations definitely a power imbalance. I mean, the most obvious is if one party or another comes with a legal advisor and the other doesn't. Is it your role to step in and play that role? No, it's not. But it is your responsibility as the mediator to ensure that your practice and the way you conduct the mediation allows for a process that is very fair, procedurally fair, and allows for that self-determination so that people can make decisions as they go through the mediation. And dealing with power imbalances might just be that you have to give one party or another more breaks, or the opportunity to get on the phone and ring somebody, or have a little bit more time to talk if they're not as eloquent as the other party. I have up there, there's no uniform opinion about a patently unfair outcome. There's been so much discussion, and it's probably a good tutorial question or a good exam question. We bring our values to whatever we do, and it's very important that our values and that we don't take those on and share them. And I'll just give you a couple of examples of that. In say a family law mediation, it might appear that one party is far more powerful, more aggressive, more vocal, more opinionated. But that doesn't mean that an outcome that doesn't quite seem equal isn't the right outcome for the other party. The other party might, for instance, have developed another relationship and they're more than happy just to move on. They might, have other ambitions in life. You can't necessarily know those. Well, remembering that at any time during the process you can stop and have a separate session or caucusing section. And if I was a mediator and I was observing that sort of behaviour, and you're absolutely right. I mean, that's one of the problems of court-ordered. People might think, oh, it's just a process I have to go through. But I would be attempting to still turn them around and doing a reality check with them. Well, what is the alternative? What is it going to be like going back to court? First of all, it's public, excepting in the family court, of course. Might cost you a lot of money. I mean, it's going to go on, the problem's going to go on. Do you really want that to occur? Certainly continuing to work on it. But in the end, if people are not there in good faith, then I think it's up to the mediator to close the mediation, because remembering that you've got to be fair, procedurally fair to everybody. And if that person's not serious about being there, then it's not fair on the other party who is there in good faith. And so I wouldn't necessarily go back to the other party and say, I'm going to terminate this because the other party is not here in good faith. But I think it's okay to say there's not likely to be an outcome in this matter and that another process is required. So the question was, in a power imbalance, for instance, when one party is represented by a legal advisor and the other party is not, what would you do? Well, first of all, I would know that before the mediation starts, because I've already found that out. I'll be asking those questions. However, I have been caught out where people bring legal advisors or bring support people and they haven't told you, but you will know that up front. I would certainly advise the other party or parties that Party A is going to be represented. I will have set some guidelines about how that legal advisor is, what that legal advisor is going to do in the mediation, the role, in other words, that they're going to play. And I would encourage the other party to either get a legal advisor or bring a support person. But, part of self-determination is that the parties decide for themselves what they want to do. And if that's the case, then, it's really important as the mediator to have a very fair, very balanced process that enables, if there is a power imbalance, that the other party has a full opportunity to advocate for themselves. And well, that's one of the reasons why you have the preliminary interview, because you'd certainly be checking that out. And the jurisdiction where that is most prevalent, of course, is in family matters. And for that reason, a lot of mediators use shuttle mediation in that area. So the parties never sit together, particularly if there's a domestic violence order. Look, fortunately, a lot of people, most people aren't violent. You can deal with aggression because you can remind them that, there are ground rules and those will usually be set up front. Yes, I have had violent people and I would, stop the mediation and give some feedback about that and how it will impact, and generally then people pull themselves into line. But if you were concerned about that, you'd have to take precautions for yourself. So you'd have a mediation in a public place, you'd have security people around, you might have a panic button there. You might do co-mediation, for instance, I have actually, and so the question was, have you ever had a situation where the power imbalance has been, I'm paraphrasing here, so evident that you've had to sort of step in to assist the other party? I did have that situation really only once, and it was actually a referral for mediation out of the ACT Supreme Court. And it was an Asian person who was accustomed to the law in the country that person came from and the way that things were done. And when I did the preliminary meeting, I was of the view that that party was not coming in good faith. She said she was, but my view was it wasn't a deliberate thing, it was a cultural thing, and that it was going to be very difficult. The other parties asked that the mediation continue, and in that regard, what I found I had to do, because there were distinct language problems, I had to do a lot of paraphrasing, rewording, constant checking with the party to make sure that the language used by the other people was accurate and understood. And just as I predicted, there was no way in the world that there could be a settlement in that matter.